Newly unsealed court documents reveal that a former White House counsel to President Barack Obama provided advice to Jeffrey Epstein during critical legal and reputational battles. This isn't speculation, it's in the filings, but the real story isn't about one lawyer's client list. It's about how power protects itself, how elite networks function, who gains access to top-tier legal and political fixers, and why these connections only surface years after they mattered. Today, I'm breaking down what the documents actually say, what they don't say, what this reveals about the machinery of influence in Washington. Let's establish what's actually been reported, according to court documents recently made public. Kathryn Ruemmler, who served as White House counsel under President Obama from 2011 to 2014, provided advisory services to Jeffrey Epstein. The documents indicate this relationship existed during a period when Epstein was navigating significant reputational damage and ongoing legal exposure stemming from his 2008 conviction in Florida for procuring a minor for prostitution. Ruemmler is not a minor figure. As White House counsel, she was the president's chief legal advisor. She managed judicial nominations. She handled executive privilege questions. She was, by any measure, one of the most powerful lawyers in the country during her tenure. After leaving the White House, Ruemmler joined the law firm Latham & Watkins, one of the largest and most prestigious firms in the world. According to reporting from the Wall Street Journal and confirmed in these filings, her work with Epstein occurred during her time in private practice. The nature of the advice is described in the documents as relating to both legal strategy and reputation management. Epstein, despite his 2008 conviction and registration as a sex offender, was actively working to rehabilitate his image and maintain access to elite social, academic, and financial circles. This is not the first prominent name connected to Epstein's post-conviction network. Previous reporting and court releases have documented relationships with lawyers, academics, politicians, and business figures, many of whom have claimed their interactions were limited or purely professional. Ruemmler's representatives have stated that her work was limited in scope and conducted through proper legal channels. There is no allegation in these documents that Ruemmler was aware of or involved in any criminal activity, but the political questions remain. To understand why this matters, you need to understand how Epstein operated. After 2008, his conviction should have ended his access to elite circles. A registered sex offender, having pleaded guilty to crimes involving a minor, would typically be socially and professionally radioactive. Epstein was not, according to reporting from the Miami Herald's Julie K. Brown, whose investigative work was instrumental in reopening scrutiny of Epstein. He maintained relationships with prominent figures across multiple domains well after his conviction. He visited Harvard University, where he had donated millions. He hosted gatherings at his Manhattan townhouse and private island. He flew guests on his private aircraft. How? Through deliberate reputation management. Court documents and reporting from multiple outlets, including the New York Times, Vanity Fair, and the Wall Street Journal, have detailed Epstein's strategy. He hired elite public relations consultants. He retained high-powered lawyers not just for litigation defense but for image rehabilitation. He cultivated relationships with journalists, offering access and story tips. The goal was straightforward: maintain enough legitimacy to continue operating in elite circles despite the conviction. This is where advisors like Ruemmler become significant, not necessarily because of anything improper, but because of what their involvement represents about the accessibility of elite professional services to someone like Epstein. Let's be clear about something: lawyers represent unpopular clients. That's how the legal system works. Criminal defense attorneys represent murderers. White-collar lawyers represent fraudsters. The representation itself is not evidence of endorsement or complicity, but there is a distinction between criminal defense representation and the kind of advisory work described in these documents. Ruemmler was not representing Epstein in a criminal proceeding. According to the filings, her role involved strategic advice on reputation and legal positioning. This is the kind of service that elite fixers provide to clients seeking to manage public perception while navigating legal exposure. The question isn't whether this is legal. It clearly is. The question is what it tells us about how access to this tier of professional service is distributed, according to analysis from legal ethics scholars quoted by Law and Crime. Former high-ranking government officials who enter private practice often command premium rates precisely because of their connections and credibility. Their value to clients isn't just legal expertise, it's the implicit signal that serious establishment-connected professionals are willing to be associated with them. For Epstein, retaining someone of Ruemmler's stature sent a message. He remained within the bounds of legitimate society, his conviction notwithstanding. The timing of this advisory relationship matters politically. According to the documents, the work occurred after Ruemmler left the White House, but while she remained a prominent figure with ongoing relationships in Democratic political circles. She was reportedly considered for nomination to the federal bench and the Supreme Court. This creates a retrospective problem for the Obama network. Not because there is evidence of wrongdoing during her government service, there isn't, but because it raises questions about vetting, awareness, and the insularity of elite professional circles. When did Obama administration figures become aware of the Ruemmler-Epstein connection? Did this factor into any subsequent personnel decisions? What due diligence, if any, was conducted on Epstein by those entering his orbit after 2008? These questions remain unanswered. The narrowest interpretation is that this is simply a lawyer taking a client. Ruemmler, in private practice, was approached by or referred to a client seeking legal and strategic advice. She provided that advice within ethical bounds. The client happened to be someone who would later be exposed as a serial predator. But at the time, he was a convicted but legally free individual seeking professional services. Under this view, there's no story beyond the unfortunate optics. Lawyers take clients. Some clients turn out to be monsters. That's not the lawyer's fault unless they participated in or enabled the criminal conduct. Ruemmler's representatives have essentially advanced this position. Emphasizing the limited and proper nature of the engagement, a broader interpretation focuses on systemic failure. Epstein's ability to retain someone like Ruemmler and the many other prominent professionals who worked with him post-conviction represents a failure of elite networks to police themselves. According to this view, advanced by journalists like Julie K. Brown and commentators across the political spectrum, the Epstein case reveals how wealth and connections can effectively neutralize legal and social consequences. A registered sex offender with money could hire the best lawyers, consultants, and reputation managers. He could continue accessing elite institutions. The formal sanction, the conviction, the registration meant little in practice because informal networks of access remained open. Ruemmler's involvement is significant under this framework, not because of anything unique she did, but because she represents the caliber of professional who remained willing to associate with Epstein. If even former White House counsel would take him as a client, what signal did that send to others conducting due diligence? A third framework focuses on political implications. The Obama administration has faced retrospective questions about its connections to Epstein-adjacent figures. Epstein visited the White House during the Obama years, according to visitor logs, though these visits reportedly involved meetings with other officials, not Obama himself. Other prominent Democrats have faced scrutiny for Epstein connections, including former President Clinton. Under this framework, the Ruemmler revelation is part of a broader pattern that raises accountability questions. Not criminal accountability, there is no evidence of criminal conduct by these political figures, but political accountability regarding judgment, vetting, and the insularity of elite circles. Critics from the right have seized on these connections to attack Democratic leadership. Critics from the left have used them to argue that elite accountability is illusory regardless of party. The political reality is that both parties have Epstein-adjacent figures, and neither has fully reckoned with what that means. A fourth framework warns against instrumentalizing legitimate questions. Epstein's crimes were real. His victims deserve justice and acknowledgement. But the Epstein case has also become a vector for conspiracy theories, partisan attacks, and disinformation campaigns that obscure more than they reveal. Under this view, each new document release triggers a cycle. Genuine journalists report facts, partisan actors spin those facts for political advantage. Conspiracy theorists weave them into elaborate narratives, and legitimate accountability questions get lost in the noise. The Ruemmler story could be genuinely significant, or it could be a relatively minor detail elevated for political purposes. Distinguishing between those possibilities requires careful attention to what the documents actually say versus what people claim they say. Let me be specific about the evidentiary gaps. We don't know the full scope of Ruemmler's work for Epstein. The documents reference advisory services related to reputation and legal strategy. They do not provide detailed billing records, communication logs, or specific advice given. The characterization as limited comes from her representatives, not independent verification. We don't know who referred Epstein to Ruemmler. Elite professional relationships typically flow through networks. Someone makes an introduction. Understanding that network would tell us more about how Epstein maintained access. This information is not in the public documents. We don't know what Ruemmler knew about Epstein's ongoing conduct. The 2008 conviction was public. The full scope of Epstein's predatory behavior, dozens of additional victims, the infrastructure of abuse was not publicly documented until years later. What due diligence professionals conducted before engaging with Epstein is not known. We don't know how this relationship affected, if at all, Ruemmler's subsequent career. She was considered for judicial appointments, whether the Epstein connection was known to vetting officials, and whether it factored into any decisions is not public. We don't know the full universe of professionals who advised Epstein. These documents reveal one name. Previous releases have revealed others. The complete picture of Epstein's professional network remains incomplete. More names may emerge. Anyone claiming to know the full story is outrunning the evidence. This creates a manageable but real political problem for figures associated with the Obama administration. Ruemmler was a senior official. Her post-government career choices reflect on the network's judgment, at least optically. Republican opposition researchers and media figures will use this connection to raise broader questions about Democratic elite accountability. The defense is straightforward. Ruemmler's private practice decisions were her own, made after leaving government, and there's no evidence of improper conduct. But in political terms, no evidence of improper conduct is often less powerful than the headline association. Expect this to surface in political attacks during campaign cycles, particularly if figures connected to the Obama administration seek higher office. The broader implication concerns how professional gatekeeping works or doesn't. Bar associations, corporate boards, university administrations, and prestigious law firms all have reputational interests in who they associate with. The Epstein case has repeatedly revealed failures in this informal gatekeeping. Epstein was on the board of Harvard's program for evolutionary dynamics after his conviction. He was welcomed in elite social settings. He retained top-tier professional advisors. Each revelation chips away at the assumption that elite institutions effectively screen for bad actors. The Ruemmler disclosure is incremental, but it contributes to a pattern that undermines institutional credibility. Victims and their advocates have pushed for full disclosure of Epstein's network, not just the criminal perpetrators, but the professional enablers who allowed him to continue operating. Each document release advances that goal incrementally, but the process is slow, legally constrained, and subject to powerful interests seeking to limit exposure. The Ruemmler disclosure may prompt calls for further investigation into who else advised Epstein and what they knew. Whether those calls produce meaningful action depends on political will that has been inconsistent. Here's the uncomfortable truth this story illustrates. Jeffrey Epstein didn't operate in a vacuum. His ability to continue accessing elite circles after a conviction for sex crimes required the active participation of professionals, lawyers, publicists, consultants, academics who provided services, lent credibility, and maintained access. Most of those professionals likely didn't know the full scope of his conduct. Many probably conducted themselves ethically within the bounds of their engagements, but collectively, their participation enabled a predator to continue operating with a veneer of legitimacy. The Ruemmler disclosure is a window into that system. Not evidence of criminality on her part, the documents allege none but evidence of how the system works. How money and connections purchase access to the best professional services, how formal legal consequences can be effectively neutralized by informal networks of legitimacy. That system didn't end with Epstein's death. It continues operating today for other clients in other contexts. The question isn't just what Kathryn Ruemmler did or didn't do. The question is what we expect from elite professionals when they choose their clients and what accountability exists when those choices enable harm. That's what the documents show, what they don't show, and what the political implications are. Sources for everything I've cited are in the description, the court documents, the reporting. The named analysts, check them yourself. If this kind of analysis is useful political mechanics instead of speculation, frameworks instead of outrage, subscribe. I'm trying to cover these stories the way they deserve to be covered. What do you think the accountability standard should be for elite professionals who take clients like Epstein? Let me know in the comments. I'll see you in the next one.